Hi, I'm Rob Johnson from the law firm of R.D. Johnson Law Offices, and in this video we're going to talk about how real estate investors can protect their assets. We did a previous video. If you can look up that one, or we'll put a link down below this video on how to protect personal assets. But I think it's best for real estate investors to separate their real estate investments from their personal asset protection trust, from their personal assets even, because those rental properties can end up causing a lawsuit. Whenever you have a renter, you have a potential adversary that might end up suing you, so that's always an issue. The other issue is what happens to that real estate investment if you get sued personally, and whether or not the judgment creditor can go after and seize or foreclose that rental property. So, and that same principle will apply whether it's commercial property or residential property. So with the traditional thing that real estate investors do, they'll set up usually an LLC, and if they're astute investors, they'll probably put one property, and if they have more than one property, they'll put a property into each separate LLC. So they might have multiple LLCs at the end of the day. Each one with one property in it, or maybe some investors will put a couple of properties into one LLC. And the LLCs are great, and again, that's traditionally what we've used in the past for protecting real estate investments. First of all, the LLC will protect you personally from liability. If the company gets sued, there's a lawsuit, they have to come against the LLC, and the LLC is there to shield you from personal liability personally, so that they won't be able to go after your personal assets. Of course, if you've protected your personal assets, you're even more shielded, but even if those assets aren't separately protected, a claimant against the LLC should be limited to what's in the LLC. Now, that's the great aspect of the LLC. One of the downsides, though, is if you get sued personally, somebody sues you on the side of collecting against the assets in the LLC does that as well, but differently than a trust will, that we'll talk about here in a minute. With the LLC, what happens if you get sued personally and a judgment creditor wants to try and get to the assets that are in the LLC, they're going to be limited that way. What the Nevada law allows or specifies as the sole remedy for a judgment creditor of a member of an LLC, and by the way, this is one reason why Nevada LLCs are particularly good, is our law is very specific and explicit that this is the sole remedy of a judgment creditor. What that sole remedy is they can go into court. Once they've got the judgment, they can ask the court for what's called a charging order, which is really like a lien. It allows them to lien or to charge your right as a member or shareholder of that LLC. If there's any distribution of profit, it liens that distribution. So the charging order is really an order from the court that if there's a distribution made to that member that has the judgment against them, to deliver that payment to the judgment creditor. So they would get that profit distribution. But under the Nevada law, the good news is the judgment creditor can't force the LLC to make a distribution. They can't foreclose the lien or try and wiggle some other remedy out of that charging order. They just have to sit and wait and hope that you're dumb enough to make a distribution. If you do, then they would get that distribution. So that's what an LLC does. Now, one of the downsides with that is if you have a judgment, you're really at a stalemate with the judgment creditor. You've got income coming into the LLC, but you can't take it out, because when you take it out, it will be ordered to be delivered to that judgment creditor. So you've got rents coming in that may pile up there, but that you can't get where you need it to pay your house payment, your car payment, whatever else your expenses are. So that's the downside with the LLC, the good and the bad. Now, one reason I like to use a real estate trust that we prepare. It's actually an asset protection trust. It allows you to protect the assets in the trust just like an LLC. It gives you that shield of separation. If somebody sued the trust, the owner of the property, they have to look to what that trust owns for any recovery, and ideally it's just that property and nothing else. So it protects that way, the same way the LLC does. And also it provides additional protection. Now if you get a judgment against you personally, for example a car accident, and it's a future judgment creditor after you've set this up and put the property into it, then they won't be able to go after the assets that are in the trust. Under the Nevada law, they have to prove fraud by clear and convincing evidence in order to get into that trust. And of course, if it's someone who's come along after the transfer to the trust, then they're not going to be able to prove fraud because they didn't even exist when that happened. So that's the way that works. Now, the LLC is supposed to be for business, to provide for your, just take care of business and not to provide for your personal needs. So if you've got a charging order where you're tied up and can't get the money out, if you try and start using the company money to pay your personal expenses, and the judgment creditor find out about it, they'll try and do what's called a reverse alter ego veil piercing to get into the LLC on the theory that you're the alter ego of your company. You treat it like your own personal piggy bank. Therefore, they should not be forced to recognize that fictitious shield of protection that the LLC provides. So you may end up with them getting into that LLC in that scenario if you try and use it for your personal expenses. On the other hand, the real estate trust will allow you to use the rent money. If you get a judgment against you, you stop taking distributions to yourself personally, and the trust instead can write checks to pay your house payment, your kids' school tuition, whatever personal expenses you have, your electric bill, your gas bill, directly out of the trust to where it needs to be paid. And you won't take that distribution to yourself where you might get hit with a garnishment while it's in your hands or in your bank account. Now, so that's double protection. This protects but keeps you tied up with the money. This allows you the protection from judgments against the trust and prevents judgment creditors from getting into the asset that's in the trust. So that's very good protection. The trust as well, just like your personal asset protection trust or your personal living trust, it'll have the death beneficiary provisions to spell out who gets what when you die. That asset will avoid probate, so that will take care of that side. In addition, the trust can give some anonymity. In Nevada, a trust can hold property in its own name, so if you give the trust an anonymous name and record it in the name of the trust, that makes it difficult for people that are thinking about suing you. If they're snooping around to see what assets you own, it makes it harder to find. So anyway, all said and done, I think the trust is a great way to go. Another couple of great benefits, by the way, is it's a one-time setup fee to set up the trust. Unlike the LLC, you set it up, pay the formation fees and attorney's fees if you or whoever sets it up for you. But then you're going to have to pay annual filing fees each year to the Secretary of State. You'll have to maybe pay resident agent fees if you've got an independent resident agent. Again, one-time cost here, ongoing cost for a long time. So it won't be very long before this will have been a much better value than the LLC will be. So that's a great way to go. Another big benefit is there's always the potential if you put a property into an LLC that if it's mortgage property, that it could trigger the due on transfer clause. And that could be a problem. Now, it's very rare for that to happen, for a bank to call the note due on transfer clause. Many people have been putting properties into LLCs for years, but it can happen. Now, with the trust, there's actually a federal law called the Garn-St. Germain Act that says if you put mortgaged property into a trust and the borrower is the beneficiary of the trust, then the bank can't trigger the due on transfer clause and call the note due. So that, eliminates that risk. Now it has to be, I believe it's 4 unit or less. So if it's an apartment complex, that won't apply. But for single family residences and smaller properties, that will protect from any triggering of the due on transfer clause. So anyway, in sum, again, lots of great benefits to using the Nevada Real Estate Trust. We create these in our office. It's tailored specifically for real estate investments. So anyway, we've got more videos to come on different topics. If you poke around, we'll put some links in the video below, and you can find those videos that speak to different assets. Business investments is coming next. So thanks for watching.